Good morning, ladies and gentlemen. It's me, Hamad Bin Jazi, a Jordanian lawyer. Today I'm going to give you some insights regarding the international law on foreign investment, in particular the bilateral investment treaties. You know, the definition of a bilateral investment treaty is a treaty signed between two countries for the purpose of encouraging and protecting foreign direct investment to the other states. So most of the bilateral investment treaties provide for a number of very important provisions that have to be included in each of the bilateral investment treaties. The first one is the expropriation clause. So the home state shall not have the right to expropriate the property and investment of the foreign investor in its territory. The second one is the national treatment clause. Which means that the foreign investor shall be granted the same treatment and equal treatment as the domestic and national investor enjoys. For example, a few years back when I was working for one of the major US security companies and they were planning to invest in Jordan in security sector, I have initiated the process through the Ministry of Industry and Trade, and they forwarded me to the Ministry of Interior in order to get the required approvals from there. But unfortunately, they refused my application owing to the fact that the security sector is prohibited for foreign investors and only restricted for Jordanian investors. So I have reviewed at that time. I have reviewed the model, the US-Jordanian bilateral investment treaty, and I found out that there is a national treatment clause included therein. So I have appealed the decision of the Ministry of Interior, and I have informed them that the treaty supersedes the domestic law. Unfortunately and eventually, they have accepted my application, and the company was officially registered in Jordan, and they are operating until date. There is another very important provision, which is the most favored nation treatment clause, which means that for example, if there is a Japanese investor enjoying certain incentives and exemptions in Jordan, as well as protective measures, and there is a UK Jordanian bilateral investment treaty signed back in the years. So the UK investor can benefit from the same treatment as granted to the Japanese investor. Lastly, the dispute resolution provision has to be included in each and every bilateral investment treaty. Most of the bilateral investment treaty provide for arbitration mechanism beyond a number of well-known international arbitration institutions, such as the International Center for the Settlement of Investment Disputes in the US, and the ICC in Europe, and many other well-known institutions around the world. Before ending my speech, I would like to mention a very important question that has to be answered by experts in such field. Do really bilateral investment treaties encourage foreign direct investment between capital importing countries and capital exporting countries? This is a really, really important question. Also, it's very recommendable that the model Jordanian bilateral investment treaty is to be redrafted and modified according to the international standards in order to meet the expectations of Jordanian and to encourage more foreign direct investment into Jordan. Thank you so much, guys, for listening to my speech, and